So dealing with the first of those three headings, I finished yesterday by looking at the case of Steele, where, as my lords will recall, the Strasbourg court held that the police power to arrest to prevent a breach of the peace happening was lawful under 5.1c. The meaning of Steele was considered by my Lord Dyson in Williamson, Volume 1, Tab 3, which we looked at briefly yesterday. One of the arguments advanced by the appellant in Williamson for saying that pace applied to arrest for breach of the peace was that pace was necessary to ensure compatibility with Article 5 of the Convention, and that submission was rejected by my Lord Dyson at paragraph 26 on MS 1424. So on the previous page, Lord Justice Dyson's judgment dealt with Steele, and then picking it up at paragraph 26, second line. In Steele, the European Court decided that the common law rules relating to breach of the peace complied with 5.1c. Although it didn't have to deal with 5.3, it is clear, in my view, that the common law requirement that a person detained for breach of the peace must either be released unconditionally or taken to a magistrate's court as soon as reasonably practicable reflects the provisions in 5.3 quite closely. And then, just below letter G, it's unnecessary so to construe the statute in order to achieve compliance with Article 5, since the law relating to breach of the peace is compliant with Article 5. My lords, the same conclusion can be seen in the Strasbourg Court's admissibility decision in Nickel, which was not cited to the Court of Appeal in Williamson, but which is entirely consistent with it. Nickel is at volume 2, tab 10. This was another case involving a protest where the applicants were detained to prevent them committing a breach of the peace.
Sorry, just wait a minute. Yeah. Carry on, yes.
And at MS 1753, bottom half of the page, we see the court recalling its decision in Steele and setting out what that found in three enumerated parts. If we just pick it up at Roman numeral 3, two-thirds of the way down 1753, the police could reasonably fear that the applicant's behaviour might provoke others to violence, and there was no evidence to suggest that the deprivations of liberty were arbitrary. That's referring back to what happened in Steele. And then picking it up at the bottom of the page, the position is the same in the present case, and it goes through each of the Roman numerals, and then picking it up a quarter of the way down 1754, Roman numeral 3. The police could reasonably fear that the applicant's behaviour might provoke others to violence, and there was no evidence to suggest that the deprivations of liberty were arbitrary. And then there's a similar conclusion to that which my Lord Justice Dyson drew in Williamson on the necessary application of pace. And then we see in the last few lines, the initial detention, that's the last few lines in that paragraph, the initial detention was to prevent the applicants from committing an offence. As regard the period of detention after the fishing match on the following day, or throughout the subsequent period, the applicants were being detained for the purpose of bringing them before the competent legal authority on suspicion of having committed an offence. So the first part of that language deals with limb 2 of 5.1c, and the latter part of that language deals with limb 1. So reading Lawless, Steele and Nickel all together, one has in our submission a coherent body of case law, the latter two cases in particular dealing with the English law of breach of the peace, which includes, as the Strasbourg Court well recognised, the power to arrest preventatively, making clear that Strasbourg does not in any way regard those powers as being incompatible with 5.1c. Can I then make brief submissions on the various cases which Miss Kaufmann relies on as pointing the other way, starting with Tula, Volume 2, Tab 6. The critical point, as my Lord Mance with respect rightly identified yesterday, the critical point in this case was that the court found that the second limb of 5.1c, the preventative limb, only allows preventative detention to prevent criminal offences, whereas the compulsory residence order in Tula was not based on preventing any specific criminal offences at all. So if one picks the judgment up starting at MS 1628, paragraph 37 sets out the government's submission, which is both a Limb 1 and a Limb 2 submission. In the government submission, the detention complained of was justified as there had been reasonable suspicion that the applicant had committed an offence, that's Limb 1, and also it had been reasonably considered necessary to prevent his committing an offence, that's Limb 2. The court points out that C permits deprivation of liberty only in connection with criminal proceedings. My Lord, in our submission, as I'll go on to explain when we get to paragraph 40, what the court meant by the phrase criminal proceedings was proceedings where a specific criminal offence is being relied upon by the state, either one that has already been committed in the past or one which the detention is intended to prevent in the future. That is the point that was being dealt with in Tula, and I'll explain that when we see the next two paragraphs. So looking at those two paragraphs, paragraph 39 is dealing with the government's argument under Limb 1. And you can see that from the last sentence of the first half of paragraph 39, where you see the government's submission summarised as being corresponding to the first limb of subparagraph C. And the court then says this: in the court's view, the preventive procedure provided for in the domestic law was designed for purposes different from those of criminal proceedings. The compulsory residence order authorised by Section 3 may, unlike a conviction and prison sentence, be based on suspicion rather than proof, and deprivation of liberty under Section 6, which sometimes precedes it, can't be equated with pre-trial detention. So that's Limb 1. Paragraph 40 deals with Limb 2. The government further submitted that the relevant custodial order had been made also because it was reasonably considered necessary to prevent the commission of an offence. And that was dismissed in the last 3 lines of that page. Neither the prosecution nor the President mentioned any concrete and specific offences, the only ones which are relevant in relation to 5.1c, which Mr. Tula had to be prevented from committing. The court didn't say there can't be a preventative freestanding limb to 5.1c. It said, on the facts, there were no concrete and specific offences. So that is what, in our submission, leads to the conclusion that when the court later, in Gessius, as we'll come to, says there has to be criminal proceedings and bases itself on Tula, Tula was simply saying the proceedings has to relate to criminal offences, not non-specific compulsory residence orders. Gessius and Lithuania is at the next tab, and we say, with respect, marks a wrong turn based on a misunderstanding of what was actually decided in Tula. Can we start with the Commission's reasoning before we get to the court? At MS 1648. And we can see what the applicant himself was arguing at paragraph C53. The applicant alleged that from 8th of February until 14th of March 96, he had been deprived of his liberty under the preventative detention rule, contrary to Article 5, as there had been no specific offences which he could be prevented from committing. In other words, he was arguing he was in the same position as the applicant in Ciulla. He wasn't saying, based on Ciulla, there can never be freestanding preventative detention. So that was his argument. The Commission's reasoning starts at 1650 in relevant part, at C62. And the central paragraph starts at C65. As the court stated in Lawless, 51C means that a person whom it is reasonably considered necessary to prevent committing an offence may be arrested or detained for the purpose of bringing him before the competent legal authority. Later in Ciulla, the court found that 51C only applied to pre-trial detention ordered in the context of criminal proceedings, but not to purely expedient detention at issue in that case. Well, that is with respect to rather compressed summary and not a wholly satisfactory summary of what the court decided in Ciulla. And then they go on to say, in the present case, since the detention provided for in Article 50 only had the purpose of preventing crime, with no reference to bringing the detained person before the competent legal authority, it didn't satisfy 51C. Not an altogether easy paragraph to understand when one goes back, as I invite you to in due course, to look at the Lithuanian provision, Article 51, which is at MS 1644. But whatever that paragraph means, it doesn't purport to say, the Commission didn't purport to say, that there can never be preventive detention. One then turns to the court at MS 1664, and you see again, perhaps tellingly, that the applicant himself wasn't running the case that Miss Kaufman is running. The applicant complained that his preventive detention was incompatible with 5.1 because there had been no grounds for such custody. A, as no criminal proceedings had been pending, that's limb 1, and B, there were no crimes which he should have been prevented from committing, that's limb 2. He didn't say, look at Ciulla, there can never be preventative detention. Paragraph 50 is the centrepiece of the court's reasoning. The court observes that a person may be deprived of his liberty only for the purpose specified in 5.1. A person may be detained only in the context of criminal proceedings for the purpose of bringing him before the competent legal authority on suspicion of his having committed an offence. So paragraph 50 on its face excises the language of 5.1c and ignores the second and third limb. On the basis, one sees from the footnote citation, of two cases, namely Lawless and Ciulla, neither of which actually stand for authority for that proposition. We then turn to Schwaber, which is volume 2, tab 12. This was a case which concerned detention following a demonstration outside a prison at a time of a G8 summit. The applicants, just very briefly, were standing outside a prison. They were waving banners, which on one view, I think the banners said something like free all. On one view, amounted to an incitement to spring the prisoners from prison, and on another view, invited simply the authorities to release them through some lawful means. If one turns to paragraph 77 and 78 on MS 1801, could I just invite you to read those two paragraphs?
Sorry, I lost my note. Page?
MS 1801.
Yep.
70, paras 77 and 78.
Well, it's 79, which is...
I'm going to deal with 79 in a minute.
But I mean, I think we have got the point, namely that they appear in 79 to have left open the critical point, having dealt with what you say as the relevant points in 77 and 78. They say, well, that may not be enough, even if we come to a different view on that.
Yes, well, my submission in effect is that in 77 and 78 there are three factual reasons given for saying that the case doesn't get home under 5.1c. First of all, there's a lack of specificity.
In other words, even if preventive detention is permissible, it doesn't get home on the facts.
Doesn't get home on the facts.
And then in 79 it says, well, we leave up in the air whether preventive detention is permissible.
My lord, yes. Right. Can we then turn to Ostendorf, finally? Just the previous tab. And again, it's instructive to see what the applicant himself was arguing. You can see that from paragraph 44 to 45. But in a nutshell, you can see at MS 1769, letter F, the applicant was submitting that the detention couldn't have been reasonably considered necessary to prevent him committing an offence because there hadn't been a sufficient suspicion that he had to be prevented from committing an unlawful act, i.e. a factual argument. He wasn't saying, look at Jessius, look at Schwaber, there can never be preventive detention.
I'm sorry just to pull back to paragraph 79 of Schwaber.
Yes.
But it is interesting to see that they refer to a revision of the court's long-standing case law.
Yes.
You probably would disagree with that description, wouldn't you, of the long-standing case law?
Well, when my lord comes to see, as I'll take you to briefly, the dissenting reasoning in Ostendorf, the two dissenting judges, one I think Belgium and I can't remember the national other one, say in terms there is this tension between the court's current case law and the previous case law. So I suppose at one level it depends on what one means by long-standing. But if you look at the guidance that we get in Pinnock about clear and constant, whether it's long-standing or not, it is not clear and constant.
Okay.
But the basis of that one sees on page 1800,
Yes.
MS 1800, where they refer in the footnote to Lawless, Jessius, and Engel.
Indeed, none of which, in my respectful submission, properly read, together with Chiulag, get home on the case advanced by the appellant in this case.
Yes,
Yeah.
sorry. Yeah.
So just then going back to Ostendorf, obviously it's an important case and I'm not going to go through it all now. Paragraph 66 at MS 1773 all the way through to 68 effectively repeat the line of reasoning in Schwaber. That reasoning under 5.1c is then applied at page 1776 from paragraph 77 onwards. And again, I'm not going to go through all the paragraphs. I've already taken you to paragraph 84, where the court agreed with the government submission that on the face of the wording of 5.1c, the second limb had a freestanding life. But then I have to grapple with the remaining paragraphs, as I promised I would. So just reading paragraph 85, they say that prima facie interpretation could neither be reconciled with the entire wording of 5.1c. Well, I respectfully disagree and don't understand why it can't be reconciled with the entire wording of 5.1c, and the court doesn't explain that, nor with the system of protection set up by Article 5 as a whole. They then say 5.1c has to be read with 5.3, and then says, as the court has confirmed on many occasions, the second alternative is consequently only covering deprivation of liberty in connection with criminal proceedings. In particular, contrary to the government submission, the term trial doesn't refer to a judicial decision on the lawfulness of the preventive police custody. Those proceedings are addressed in 5.4. But that is in my submission, very difficult to reconcile with what the Grand Chamber decided in the Mackay case I took you to yesterday. I'm not going to go back to it. It's tab 57 MS 2818, where the Grand Chamber said that it was Article 5.3 that requires the judicial officer to consider the merits of the detention. So it isn't only arising under 5.4. Then we see what the court says in paragraph 86. The court says, the court further observes that contrary to the government's view, the second alternative of 5.1, I think it must mean 5.1c, can't be considered as superfluous in addition to the first. A detention under 5.1c may be ordered, in particular, against the person having carried out punishable, important word, preparatory acts to an offence, in order to prevent him committing that latter offence. That person may then be brought before a judge to be put on criminal trial for the purposes of Article 5.3 in respect of the punishable preparatory acts. In my respectful submission, the Court of Appeal got it spot on when it criticised that paragraph. If I could ask you to turn to the Court of Appeal's judgment. It deals with that paragraph of Ostendorf in paragraph 66. But I just invite you to read paragraph 66 of the Court of Appeal. In my respect,
it's not the explanation which Miss Kaufmann gives. She says this is put in to deal with the fact that although the basic requirement is that you're arresting someone on suspicion of having committed an offence, if you apply ordinary principles of proportionality, that by itself is not always good enough to justify banging them up, and you may need to, as you do under English law, look for some other risks, such as absconding or committing a further offence. And she says you don't need to talk about punishable preparatory acts for a particular offence. It could just be any other offence, but you still have to have the trigger of a suspicion and intention to pursue one which has already been committed.
Well, my Lord, if that is her argument, then A, as my Lord has observed, it isn't what the court was saying in Ostendorf.
No.
And B, the requirement of proportionality is in any event in terms
of course, it's there anyway. I mean,
there anyway. You don't need to tie yourself in knots to strip out limbs 2 and 3 from Article 5.1c in order to achieve a proportionate approach to that provision.
No, but I mean, you can be asked against you. Why is the reference to fleeing in 5.1c? Well, I mean, that must be to make clear that that can be a factor in refusing bail.
Well, my Lord Reed was looking and showed the court yesterday the relevant pages 471 and 472 from Van Dyck and Van Hoof, and I read those overnight, and it does discuss the difficulty of construction in relation to fleeing, and there may be different considerations which apply when one comes to decide whether the third limb, the fleeing limb, has a freestanding existence in the same way as the second limb does. But I don't accept Miss Kaufmann's submission that if the third limb has to be read in a particular way, so does the second limb. And the authors discuss some possible different interpretations to fleeing.
They discuss it very faintly.
They do.
This appears to be the best photocopy we can produce.
Can I just say, perhaps by way of, to show you I'm not lazy, I looked overnight at the case cited called de Jong, Baljet and Van der Brink.
Yes.
And that, the critical words in that commission decision are those cited by the authors in this case. I didn't burden the court with more paper because ultimately the second limb was not part of the ratio of the case. The applicants in that case, who were detained in a military camp, I think,
Yeah.
were detained under the first limb of 5.1.
Yeah, so this is just dictum, but it's
dictum.
It's directly in your favour.
It is.
So which are the bits in this passage? Is it the first page, 4.7?
It's the first page, and the fleeing limb is then discussed at the bottom of the first page and over to the top of the second page.
So when was this book written?
I think 2000. This edition, or at least my edition, is the fourth edition, which was published in 2006.
Yes, it's long before Schwabe and Ostendorf.
Yeah. I mean, all I would say, my lord, as the court has observed, the Strasbourg court has observed many times, that court, and I would respectfully say this court, is not required to construe the convention in abstracto, nor, I would respectfully submit, to provide some grand unified theory of how Article 5 worked in every single case. We're not concerned in this case with the fleeing limb, and I don't invite my lords to give extensive guidance as to how the fleeing limb might operate. But we do say that the protective limb, for all the reasons I've already given, does have a freestanding existence.
Right.
So just going back to the Court of Appeal at paragraph 66, where it explains how the Strasbourg's reasoning in paragraph 86 of Ostendorf can't work so far as English law is concerned. In my respectful submission, it can't work in any system of criminal law. For this reason, either a preparatory act is punishable, as it sometimes is in England, in which case the Court of Appeal's criticisms are apt, or you have a system of criminal law like in Germany, where they consciously decide not to punish preparatory acts, I think as a policy decision to encourage people to give up their plans until the very last minute without fear of being punished. But if in such a system where preparatory acts are not punishable, the Strasbourg court's analysis in paragraph 86 of Ostendorf does indeed rob the second limb of any existence at all. Because 86 of Ostendorf is predicated upon a system of law where preparatory acts are punishable. But if they're punishable, then you can get them in under the first limb. And if they're not, what's the second limb doing? And then finally, just making good my submission to Lord Dyson earlier about the dissenting, or concurring in the result, but dissenting in the reasoning judgments of Judge Leymans, who was the Belgian judge, and Judge Jedeblom, who was the Swedish judge. They do, at MS 1784, fairly characterize, just above letter G, that Schwabe, in particular, represents the current, I emphasize that word, case law of the court. But then they say at the bottom of the page, we are aware of the fact that our opinion is not compatible with the current case law, but we note that this case law, without any specific explanation, derogates from what the court said in Lawless. So there is that tension, which neither the majority in Schwabe, neither the majority in Ostendorf, nor anybody in Schwabe has grappled with. And my lords have my submission as to how that tension should be reconciled. It should be reconciled by finding that Gessius effectively is based on a misreading of what the court found in Ciula. My Lords, can I then finally deal with the various Grand Chamber decisions which Miss Kaufmann relied upon to support her argument that there is a clear and constant jurisprudence? I think they were Al-Jeddah, A in the United Kingdom, Hassan and Blokhin. Al-Jeddah and A were both, in my respectful submission, correctly distinguished by the Court of Appeal at paragraph 50 of its judgment. Just picking that up very briefly. Sorry? 59, I beg your pardon. Not where the Court of Appeal said we ought to refer to A and Al-Jeddah. They both concerned lengthy periods of detention without charge or trial, which resembled internment in the sense in which that term is generally used. And with respect, precisely the same distinction applies to the Hassan case, with which I know my Lords are well familiar, the case where the applicant's brother is detained for months and then dies in custody. In fact, if anything, the Grand Chamber, in the very passage that Miss Kaufmann relies upon from Hassan, does not reject the possibility of detaining to prevent the commission of a criminal offence. If my Lords turn to volume 5, tab 51, MS 2595, this is the passage that Miss Kaufmann asked you to read, paragraph 97 of the Grand Chamber's judgment. There's a reference at the outset of 97 to the long-established principle that the list of grounds of permissible detention doesn't include internment or preventive detention where there's no intention to bring criminal charges, and it cites the case law. But then, picking it up towards the bottom of that paragraph, about 7 lines up, after the reference to the 4th and 3rd Geneva Conventions, it says, although Article 5.1c might at first glance seem the most relevant provision, there does not need to be any correlation between security internment, that's what was going on in Hassan, and suspicion of having committed an offence or the risk of the commission of a criminal offence. So the inference one might draw from that sentence is that there's nothing inherently wrong with detention for the preventative purpose, preventing the commission of a criminal offence. The Grand Chamber doesn't say that is not a possibility. So if anything, Hassan undermines rather than helps the learned friend. As to Blokhin...
Sorry, just wait a minute. Yes, I see. Yes.
As to Blokhin, which Learned Friend's written case places a good deal of emphasis on, can we turn that up at volume 1? It's in the sort of core volume of authorities. Volume 1, starting with the first section's judgment at tab 4b. My Lord, the applicant in Blokhin was a minor, preventatively detained for several months in a youth detention centre without adequate medical treatment, conditions so bad as to amount, the court found, to a breach of Article 3. As to Article 5, in the Chamber, the government first ran the rather ambitious argument that that long-term detention didn't amount to a deprivation of liberty at all. That was perhaps unsurprisingly rejected. And they also argued that the detention was justified under 5.1d because the detention was for so-called educational purposes. And that was again rejected on the facts. The government didn't even argue that the detention was justified under B or C. The court, nonetheless, of its own motion, considered those provisions briefly, and the reasons it gave for rejecting justification on 5.1c can be found at paragraph 118 of the court's judgment, starting at MS 1552. The court reiterates that 5.1c doesn't permit a policy of general prevention directed at an individual or category of individuals who are perceived as being dangerous. It does no more than afford the contracting state a means of preventing a concrete and specific offence as regards the time and place of its commission. And it cites Ostendorf. It's clear from the domestic judgments in the present case that the applicant's propensity to commit delinquent acts was gauged by reference to his unruly way of life, lack of parental control, and prior delinquent acts. Neither the domestic authorities nor the government mentioned any concrete and specific delinquent acts being prepared by the applicant, which he had to be prevented, I beg your pardon, from committing. So that is why the 5.1c limb did not afford a justification. And then they go on to, with great respect, fall into the same. Well, many friends laugh. That's our case. We say that they go on to fall into the same erroneous reasoning by reference back to Ostendorf. But there's no analysis, and in fact,
It's another reliance on the punishable preparatory acts.
indeed, but in the end, what did for the Russian government under that limb can be seen from the last 4 lines. In the present case, the court has already found that the applicant's detention in the juvenile detention centre was not effective for the purpose of bringing him before the competent legal authority at all.
But one aspect of this case law that may need to be borne in mind is that none of it is concerned with facts which are analogous to those that we're dealing with, as it seems to me. One sees in general the court's concern that executive detention without judicial control is contrary to the rule of law. And so, in general, it would follow from that preventive detention by the executive without the intention of bringing the person detained before a court would be contrary to the rule of law and contrary to the convention.
My lord, yes.
That's exactly as one would expect. I mean, the specialty in the situation we're dealing with is that the risk of committing the offence is an evanescent risk. It's transient, it lasts for a few hours, and then it effectively disappears. And so if you can, so if you detain the person for the purpose of preventing the commission of the offence, the risk of his committing it will have disappeared before he could realistically be brought before magistrates on the Monday morning, or whenever it might be. And it would be pointless and perverse to expect the police to continue to detain him longer in order to bring him before a court when the necessity to make a binding over order had disappeared.
Pointless, perverse, and contrary both to the Article 5 requirement of proportionality and the common law requirement spelled out by my Lord Dyson and Williamson, of having to bring the detained person before the magistrate's court as soon as possible, or, if the risk is dissipated before then, to release him prior to that.
Yes, I mean, I'm just wondering whether the court would... The fact is the court hasn't, as far as I've seen, addressed a situation of that kind. And, I mean, say, for example, you have somebody who is standing waiting for the cavalcade of a visiting dignitary to pass, and he's got a pot of paint that he's planning to throw. And the the police spot him with his pot of paint, and they take him to one side until the cavalcade has passed, and then they let him go. Have they infringed his human rights?
Well, my lord knows our answer to that question. The answer is no.
Well, it would seem, it would seem absurd if you have to initiate criminal proceedings in a situation of that kind. And I wouldn't have thought the Strasbourg court would be given to reaching absurd results.
Ms. Kaufmann's response, which we've just heard, is that doesn't amount to detention. Then, of course, this is really squeezing the sausage. In order to avoid the curiosity to which Lord Reid has just drawn attention, you construe detention as not detention. When is detention not detention? Well, when it would be awkward for Article 5 to apply. And on that argument, the mistake which the police made here was say you're arrested and being taken to the police station. If they'd say, no, we're not arresting you, we're just stopping you moving anywhere for the next few hours, and here are cords of iron around you, they would be able to say, well, Article 5 isn't in play at all. And so the question arises whether that is actually an intelligible way of approaching the issues addressed by Article 5.
And just to follow my Lord Reid's example through, what if, rather than apprehending the single individual with a pot of paint a few minutes before the cavalcade goes by, the police spot 10 individuals, all with pots of paint, 5 hours before the cavalcade goes by, because people assembled in the streets for hours beforehand for obvious reasons. Are they to hold them there, using up...
Yeah.
My Lord has the point.
Yeah, that's quite.
On the question of release isn't a problem, though. If you decide that there are no grounds for pursuing a criminal charge which you originally suspected, then you're obliged to release, and no one suggests that your failure to bring the person before a court is a problem under Article 5. So I would have thought if you originally intended to bring them before a magistrate, then there'd be no problem. If you decided the emergency had passed and there was no need. The problem arises where you have something which is a very short-term event, and really there's no prospect of you ever getting anywhere near a magistrate, and you presumably never intend to, if at least you may never intend to. I think you're going to argue.
I'm going to deal with the Brogan question of intention and purpose in a minute, if I may. Can I just finish dealing with Blockin? So I've dealt with the chamber, just dealing with the Grand Chamber at tab 4A. Again, the government only argued justification by reference to 5.1d rather than 5.1b or c. And the only passage of the Grand Chamber's judgment which deals with this at all is paragraph 165 on MS 1474, and at the top of 1475, where it says the applicant has submitted that his placement in temporary detention fell outside the scope of all the subparagraphs, while the government in their submissions have claimed that it fell within 5.1d, without arguing that it could also fall under one of the others. In view of this, and agreeing with the Chamber's findings that the applicant's detention didn't come within 5.1 A, B, C, E, or F, the court will focus on 5.1d. That cannot possibly be said to be an endorsement of the reasoning of the court in Ostendorf, Jessius, Schwaber, etc. So with that in mind, can I very briefly make some submissions on the Section 2 Human Rights Act obligation to take into account Strasbourg case law? I'm not going to go back to Uller, Pinnock, Chester, etc. The only point I want to pick up is something that my Lord Mance said, with respect, rightly yesterday, that none of the judgments in those House of Lords or Supreme Court cases were purporting to lay down an exhaustive code as to when domestic courts, in particular the Supreme Court, may decide not to follow Strasbourg. And the conclusion that these cases shouldn't be regarded as prescribing such a code is also made clear in one decision that is in the bundle of authorities that I don't think it's been handed up yet. Can I just briefly hand these up? It's the case of Cayenne.
Yes, but
And
James in the UK and
exactly. It was the case, as my Lord rightly says, that concerned the release of IPP prisoners who hadn't been provided with offending behaviour courses. That case had come to this court in Walker and James, then went to Strasbourg and James in the UK, and then came back in the form of Cayenne. And the approach to Section 2 of the Human Rights Act was set out in a joint judgment given by my Lord Mance with Lord Hughes, with whom Lords Neuberger, Toulson and Hodge all agreed. And we can see the relevant passages starting at page 1362 of the Appeal Cases Report. I won't go through it all, but just to pick it up, after a reference to Lord Neuberger's judgment in Pinnock at paragraph 19, and Lord Mance's judgment in Chester at paragraph 20, the judgment says this: the degree of constraint, this is paragraph 21, the degree of constraint imposed or freedom allowed by the phrase must take into account is context specific. And it would be unwise to treat Lord Neuberger's reference to decisions whose reasoning doesn't appear to overlook or misunderstand some argument or point of principle, or Lord Mance's reference to some egregious oversight or misunderstanding as more than attempt at general guidelines, or to attach too much weight to his choice of the word egregious compared with Lord Neuberger's omission of such a qualification. So applying all that body of case law as a guide and not a cage, we say that there are three broad reasons why you should not follow Ostendorf. First, given the different approaches taken in Lawless, Steele, and Nicol, it cannot be said that there is a clear and constant line of case law which this court has to follow. Second, contrary to Miss Kaufmann's case, there is no Grand Chamber decision which has expressly addressed the issue. Third, Schwabe and Ostendorf were, of course, concerned with the German legal system, whereas Steele and Nicol are concerned with the English domestic law of breach of the peace to prevent an imminent threat, so that any conclusion that preventative detention was contrary to 5.1c would be, in my submission, inconsistent with a fundamental aspect of our law. And I should, I suppose, add, for the sake of completeness, fourth, you shouldn't follow Ostendorf because it's wrong for all reasons I've given. In other words, it's wrong because of its continuation of the Gessius error and the tension with Lawless being recognised in the dissenting judgments that I've shown you. Finally, before turning to the Brogan question, can I just address Ms. Kaufmann's submission that if, as we say and she disputes, the purpose of bringing somebody before a competent legal authority is to review the legality of detention rather than to conduct a trial on the merits. She says, well, in that case, she wins. That's wrong for two reasons. First of all, as I've already said, and as is clear from Steele, a binding overhearing does, in Strasbourg terms, amount to a criminal trial. So if that is a requirement, if it is a requirement that somebody has to be brought before the competent legal authority for a trial on the merits, that is what a bind overhearing constitutes, for the reasons I explained yesterday.
what do you say about Article 5.3 then? How do we construe it on your case?
In the sense that...
Well, on the face of it, it says everyone who is arrested or detained in accordance with paragraph 1c shall be brought promptly before a judge or other authorised officer and should be entitled to trial. So it postulates that everyone will be tried who's arrested or detained, doesn't it, under 1c?
There are a number of ways of squaring the circle. Either you can construe trial as a trial of the question that is before the court, namely the legality of the detention, or you can say you read, as the Grand Chamber did in Mackay, Article 5.3 as being concerned with two separate matters, and it doesn't mean that in every single case, even those cases where there is no intention to pursue somebody to trial ultimately, there has to be a trial.
Well, more basically than that, does the duty under Article 1.3 continue after the person has been released?
Well, precisely so. It says, or to release pending trial. But
Right.
what if the prosecution
So
decide there is no sufficient evidence to bring to trial? It can't mean there has to be a trial at the end of the day.
And then, now, if Article 1.3, 5.1.3,
5.3.
5.3 is concerned with getting before the court somebody who is in detention, as distinct from investigating whether somebody had now free, had been wrongly detained, for which specific provision is made in Article 5.5, that may have an important effect, may it not, on the proper interpretation of 5.1c, because the court has habitually said that this has to be read as a coherent code.
My lord, yes.
If it be right that there is no obligation to bring before the court under 5.3 somebody who is not in detention, then the question presents itself under Article 5.1c, must there be a purpose, must the purpose of bringing somebody before a court subsist after they have ceased to be available to be brought before the court because they're not in custody?
And it's the same point I'm about to come on to in Brogan, which is at the point that somebody is arrested on suspicion of having committed an offence, the arresting officer may have no idea in reality whether there's going to be sufficient evidence to charge that person and bring him before a court.
Right. Well, you then get to this position. If purpose of bringing before the competent legal authority can't be sensibly construed as bringing them after they've been released and therefore aren't in a position to be brought before the legal authority in the relevant sense, what is the position if the foresight and intention at the outset is that that situation will never arise at all?
That situation being
Being
The evanescent
evanescence, which is the point precisely addressed by the minority
yes.
in Ostendorf and not explicitly addressed, as I can see, by the majority.
My lord, yes. And
That
I haven't,
seems to me to be the point that Lord Reid has said the court hasn't actually grappled with on any occasion.
with great respect, I agree.
Right.
One may not have to go that far, and I'll explain why in a minute when I come on to make my submissions on Brogan. But I don't dissent from anything that my lord has
But do you adopt the line of possible thought that I've
Yes.
been putting?
Yes.
Right.
At some point, I'd like you to formulate what it is you think you've adopted. So I've got your position clear, without any disrespect to that.
No? Well, let me see if I can do it
Not,
now.
you don't need to do it now.
If I don't do it now, I'm going to forget.
Take it slowly.
Sorry.
Take it slowly. Yes.
Yeah.
Lord Toulson will correct you.
The critical point to understand, I'm going to try and deal with this as succinctly as I can, about the Strasbourg case law is that it has never expressly grappled with the situation where the offence which somebody is detained to prevent them from committing is necessarily a one-off event. And if it is necessarily a one-off event, and there can be no purpose of doing anything other than release them once the eventuality has passed. Reading Article 5 as a coherent whole, one cannot require the police to have a purpose of bringing the detainee before a court, come what may. I hope that is a fair...
Yeah, I mean, it proceeds in a series of steps. Step 1, 5.1c and 5.3 have to be read together.
Yep.
Step 2, what is the ambit of 5.3? The answer might appear to be that the 5.3 duty ceases on release,
Yes.
leaving the question of a retrospective analysis of the lawfulness of somebody who has been released covered by 5.5.
Yes.
If the scope of 5.3 is as just identified, and if that is to be read as 5 together with 5.1c, must there be an intent to bring before the person to bring the person before the court after the obligation to bring them before the court under 5c has lapsed?
My answer to that question is no.
No. Then the final question is, if that be so, what is the position if you're dealing with the evanescent one-off case where you are never going to get to the stage of the 5.3 duty? Is the effect that for that reason 5.1c express power of preventive detention simply doesn't exist at all?
Obviously not.
And is that a rational
Well,
analysis?
well,
That's the final
That's the point. I mean, it seems to me this point amounts to pointing out that if you take Miss Kaufman's construction of the scope of 5.1c, it doesn't cover everything which one might have thought that it should do.
I respectfully agree with all of that. Can I now deal with why, even if you didn't go along precisely that line of reasoning, there is another answer?
But just before we do it, the point that I've been just toying with seems to me to be encapsulated in
Judge Yeater-Blom.
exactly 1784 letter H. And I can't find anywhere so far any specific addressing by the majority of that situation. Seems to me to be, therefore, in a sense, a novel one.
I respectfully agree.
They say, we think in situations where there's a vital public interest in preventing someone from committing an offence, a limited possibility exists for the law enforcing authorities to detain that person for a short period, even if he has not yet committed a crime, therefore, without the possibility that criminal proceedings will be opened against him.
My Lord.
And that is the point in a nutshell.
That is the point.
Yeah.
Yep.
Good.
Can I then develop the slightly, and it is only a slightly alternative case under Brogan, which informs, there aren't many cases that tell us what purpose means, and Brogan is the seminal one. It's Authorities Volume 1, tab 5, and we've seen it already. If you turn to paragraph 53 at MS 1584, my Lord, just remind themselves of the whole of paragraph 53. Sorry, it's tab 5, MS 1584.
Well, this is your factual point that they
No.
were. Is it not
Well,
that they were actually always potentially going to be subject to breach of the peace proceedings unless that became what unnecessary?
Can I develop it? I mean, we say that three principles, in addition to the one that my Lord Toulson has just identify can be discerned. First, and this I am sure is uncontentious, the fact that somebody arrested isn't in the end brought before the court obviously doesn't mean there's no purpose. Second, there is no suggestion that Article 5.1c says that the only purpose of arrest and detention must be to bring the person before the court. So if there are two linked purposes, A, of preventing the imminent commission of an offence, and B, the possible bringing of the person before the competent legal authority, the existence of the first purpose does not exclude the existence of the second purpose. And third, and this I suppose is the heart of my alternative submission, alternative to my Lord Toulson's reasoning, provided the police act in good faith, there is no requirement that bringing the detained person before the competent legal authority must, in the arresting officer's mind or the detaining officer's mind, be the likely outcome of the detention. Such an approach, advocated in effect by Miss Kaufman, would run entirely contrary to the fundamental principle that I started with yesterday, that Article 5 can't be interpreted so as to make it impracticable for the police to fulfil their duties, provided that the individual is protected from arbitrary detention.
Just remind me, I've got it in my notes somewhere, which was the case where that stated most succinct? Austin, yeah, thank you.
In reality, as in Brogan, the police will not know, generally, at the time of the arrest, what the investigation might reveal, or, in the context of the present case, how the facts on the ground, which gave rise to the fear of the imminent risk of the peace, will develop. So in our submission, even assuming my Lord Toulson's first line of reasoning were put to one side, for Miss Kaufman to succeed, she would have to satisfy you that the only proper inference to be drawn on the facts, contrary to what the Court of Appeal found, is that at the point of arrest and at every material time thereafter, the police officers knew they were going to release the applicants come what may, and regardless of how matters developed on the ground. They were never going to be brought before the magistrate's court.
Why do you, I mean, I know you have to put it that high for the argument to work, but I don't see why you do. I mean, if on the evidence, as it clearly was the case here, the high likelihood is that they were going to be released at the end of the wedding in 4 hours' time.
That's not good enough for her case. That's my point. The mere fact that
why not? I mean, it's clear. I can see if the purpose, as in Brogan, is that they will be brought before a court if the evidence is obtained, then obviously there's a realistic possibility they will. But if on the evidence there's no realistic possibility or no sensible likelihood that they're going to be brought before a court, why should the court proceed on some other basis?
My Lord, at the moment of arrest in this case, and when the applicants were taken to the police, appellants were taken to the police station, no doubt, or very likely, the arresting officers hoped and expected that once the kiss on the balcony, the famous kiss on the balcony, had taken place, the crowds would disperse and the risk of violent demonstration and counter-demonstration would dissipate. It would be an evanescent risk. But that was obviously not inevitable.
No, of course not. We understand that. But I mean, if the police had been asked, they'd say, well, you can expect to be out in 4 hours' time unless something very, very odd happens. Well, that was a fact of the matter, and it didn't happen. So how can you sort of construct a notional intention which simply didn't exist?
I mean, my Lord says something very, very odd. All I would say is if the operational officers were sitting behind me, they would say, well, a month before, there had been huge riots in London, in central London. It was by far from inevitable that we were going to release them at a certain stage in the afternoon. And my case is simply this, that the likelihood that they were going to be released doesn't mean there was no purpose to keep them in order to bring them before the magistrate's court until it became clear, as it did, that the risk had dissipated. And if it cannot be enough for Miss Kaufman to say, look, They thought it was likely that they were going to be released in sometime in the evening or the afternoon. That's what happened. There can have been no purpose.
And what are we arguing about here? We're arguing about a phrase which the European Court of Human Rights has read into Article 5, namely that the arrest or detention must be effected for the purpose of bringing him before the competent legal authority, are we? Or is that...
And that's in the language.
No, it's okay. We're arguing about what 5(1)(c) means.
We're arguing about what constitutes a sufficient purpose.
Yes, so I mean, on the
But
face of it...
that has been in the case law since right back to Engel, the idea that 1C has to be for the purpose of bringing
Yes.
before the competent court. I mean, I'm looking at Engel now.
I mean,
So
the
that's
question is, what does purpose mean?
Yes.
And that's the debate
Yes.
that we're having with...
And
this-
you're...
It's unlikely to mean...
You know, I
remote
understand the
possibility.
way you're putting it, but it does seem to be a very artificial constraint. You know, if purpose is necessary, which on
Well, it is
my Lord
necessary.
Ortulson's purpose it isn't, but if it is necessary, then it seems to be a very artificial view you're taking of.
Well, with respect, my lord, it's not us that's taking the artificial view. It's Miss Kaufman's case that takes the artificial view, because she says, effectively, you can, unless the officer has a fixed intention at the moment of arrest and at all times thereafter to bring before the competent legal authority, the purpose is not there. I'm saying the other way. Unless it is clear that the officer had no intention, come what may, to bring before the magistrate. I mean, the common law requires either release as soon as reasonably practicable or bringing before the magistrate at the next available opportunity. And that, we say, marches completely hand in hand with what the test of purpose is in Article 5. So my learned friend then, just to deal with her forensic argument on the custody record, where at the end of each custody record there's a reference to disposal and bind over, breach of the peace, and then no further action, release. She says those show that we never really intended to take them before a bind over. In fact, on the contrary, what the records read as a whole show is that the police were complying with their duty to release Miss Kaufman's clients as soon as it became clear that the risk had dissipated. It's a non sequitur to turn that on its head and to say they show that we were somehow acting unlawfully because we never had an intention to take them to the magistrate's court. All the custody records under the disposal heading on their face refer to binding over, and therefore on their face suggest that some consideration was given to the possibility of taking the police to the taking the applicants to the magistrate's court, but that wasn't in the end pursued. And the references to each of the custody records are set out in an appendix to our written case for my Lord's note at MS 145. Ms. Kaufman then says, oh, those are all purely formulaic. Those references to binding over essentially are meaningless. And there I am entitled to take the following procedural point. My Lords may recall that at a very early stage of this judicial review case, the respondent, my client, advocated strongly that this claim should proceed by way of a witness action, either in the county court or in the Queen's Bench division. Because, we said, there were likely to be evidential, factual disputes that needed to be resolved. No, said the claimants, it can properly proceed as a judicial review because there are not going to be anything other than some residual factual disputes. Now, that, with respect, it wasn't Miss Kaufman who advocated that, it was her predecessor, but that's by the by. Having chosen to pursue this claim by way of judicial review, not having cross-examined the makers of these custody records about their meaning, or anybody else who gave evidence for the Metropolitan Police, there were plenty of witness statements, it cannot now be open with respect to invite my learned friend to go behind them, to go behind the custody records, and to invite you to conclude, as if you were a first-tier tribunal of fact, that they mean something other than what they say.
Just can you give us a reference to where you say originally it was advocated that this should go by witness action?
It's dealt with both in the divisional court's judgment and in the Court of Appeal's judgment.
Yeah.
That is recorded. My learned junior will just find the, not a junior at all, my learned Queen's Counsel will find the relevant paragraphs. My Lord, that's all I want to say on the Brogan purpose question, unless my Lord my lords want to test me on it any further. Can I finally, in the last quarter of an hour, deal with our case on Article 5.1b? Our case in summary is that that provision cannot invariably require a warning to be given, even where an effective warning is unrealistic, as the divisional court found on the fact in this case. And the starting point is the decision in McVeigh, Volume 2, Tab 9. I'm not sure that my friend referred you to McVeigh yesterday, but I don't think we actually went to it. McVeigh was a case where the applicants came off the ferry from the Republic of Ireland at Liverpool and were detained in order to be questioned in connection with terrorist activities, although on the facts, the police, the Commission, decided the case on the basis that they were innocent holidaymakers. And you can see that from MS 1720. Paragraph 158, where the Commission noted that according to the government, the applicants had been arrested and detained because some suspicion arose that they were involved in terrorist activities, but the Commission emphasises that whatever the belief, there was no evidence before it, and it hasn't even been alleged before the court that the applicants had been so involved. The Commission therefore approached the case on the basis that the applicants were innocent holiday makers. Then, just picking it up at paragraph 161 to 163, the only point I wanted to emphasise is at 163, last line of MS 1721, Articles 5.1b and c are not mutually exclusive. That's clear authority for that proposition. And then the important principle recognised by the Commission can be found at paragraphs 173 to 175. So, picking it up at MS 1724, Paris 173, the applicants submit that 5.1b goes further than this, that the obligation must be an antecedent one, and some voluntary failure to comply with it must already have taken place before detention to secure its fulfilment is justified. The Commission considered there's much force in that argument, and it goes back to Engel. And then it says this branch of 5.1b is primarily intended to cover the case where the law permits detention as a coercive measure to induce a person to perform a specific obligation which he has willfully or negligently failed to perform hitherto. Nonetheless, 5.1b doesn't expressly require that there should have been such a deliberate or negligent failure. It requires only that the purpose of the detention should be to secure the fulfilment of an obligation. This doesn't expressly exclude the possibility of detention in the absence of a prior breach of legal duty. However, the mere combination of unfulfilled obligation, even if concrete and specific, coupled with the relevant purpose isn't enough. That would open up the possibility of arbitrary detention. Then para 175. In the Commission's opinion, there must accordingly be a specific circumstance such as to warrant the use of detention as a means of securing the fulfilment of an obligation. First to Winterwerp, then picking it up on the third line of the next page. The mere fact that an unfulfilled obligation is incumbent on a person isn't enough. In the Commission's opinion, the person must normally, I underline that word, have had a prior opportunity to fulfill the specific and concrete obligation and have failed without proper excuse to do so. However, third line from the bottom, there may, in the Commission's opinion, be other limited circumstances of a pressing nature which could warrant detention in order to secure fulfilment of an obligation. And that is then picked up later on. Just dealing with 181 on the next page, the Commission finds that the purpose of the detention pending examination of the present applicants was essentially to secure their compliance with the overall obligation to submit to examination. It was not based on any specific failure on their part to fulfill the legal obligations. The basis of arrest wasn't any refusal or failure to answer questions. And then the last four lines, the purpose of the arrest was not, therefore, to compel them to rectify any specific prior breach of legal duty. It was to compel them to submit to further examination. And then Lastly, paragraphs 190 to 191. The Commission has already observed that the applicant's detention wasn't based on any prior voluntary failure. It reiterates that in the absence of such circumstances, detention cannot normally be justified, and it goes on to explain the general position. And then 191 is critical. In considering whether such circumstances exist, account must be taken of the nature of the obligation. It is necessary to consider whether its fulfilment is a matter of immediate necessity, and whether the circumstances are such that no other means of securing fulfilment is reasonably practicable. A balance must be drawn between the importance in a democratic society of, this is the fair balance principle, of securing the immediate fulfilment of the obligation and the importance of the right to liberty. The duration of the period of detention is also a relevant factor. So, very important passage. In our submission, where the fulfilment of an obligation is a matter of immediate necessity, as we say it was in our case, such that no other means of securing the obligation is reasonably practicable, as we say they were not in our case, and the detention is short, as it was in our case, Article 5.1b will not generally require a warning to have been given, because in those circumstances it cannot possibly be said that the detention is arbitrary. Ms. Kaufmann says this is just a Commission decision. It's old, it hasn't found an echo in the recent case law. That is wrong. It's directly supported by the Grand Chamber decision in Saadi, which is in that small clip that I handed up that contained the Cayenne case. So Saadi, as my lords may recall, concerned the temporary detention of an asylum seeker, and the only passage to take you to is at page 450. If I could just invite you to read paragraphs 68 through to 70. Page 450. And one can see from the footnote 55, which is on the last line of paragraph 70, a reference down at the bottom of the page to a case of Vasileva and McVeigh. So when Ms. Kaufmann says it's an old Commission decision, hasn't got any currency in today's case law, with respect, she's wrong. How does one reconcile that with Ostendorf and Schwaber, which make no mention of McVeigh or Saadi? The answer is, again, fact-specific. On the facts of Ostendorf, there was a warning given, so one didn't need to get into this branch of the case law. And in Schwaber, it's clear that the court took the view that a warning would have been possible. So just dealing with each of those in turn, because I haven't looked at Schwaber or Ostendorf for what they say about 5.1b, just picking up Authorities Volume 2 and starting with Ostendorf at tab 11, paragraph 95, which is at the foot of MS 1779. The court describes how the applicant was ordered to stay with the group with whom he had travelled from Bremen to Frankfurt, warned in a clear manner of the consequences of him failing to comply with the order and that he would be arrested if he didn't. But what if there, I ask hypothetically, had been a different situation? What if Herr Ostendorf had been seen for the first time, not in the pub, some distance away from the stadium, but in the stadium, by a police officer maybe 10, 20 meters away from him, about to start a fight with a group of opposing supporters. It cannot be, applying Article 5 realistically, that the officer would have to shout a warning to Herr Ostendorf and then only arrest him when he breaches that warning and starts the fight. As to Schwaber,
But if not, I mean, what would be the obligation? A striking feature of the cases you've just taken us to is that in each case, detention is seen as a coercive measure to secure the performance of an obligation, which might be to give your name or to give your address, or it could be to allow access to your child, or all sorts of possibilities. But what would be the positive obligation?
well, in the Schwaber example I've just given you, the specific obligation on the concrete facts of the case would be not to get into a fight. Nobody could realistically say, well, that's not really that specific. This isn't a situation in which the police are saying, either in our case or in Schwaber, you have a general obligation to obey the law of the country.
But you're not then using detention as a means of coercing the person to perform an obligation. You're simply detaining him for preventive purposes, to prevent a breach of an obligation.
I mean, my Lord's question may feed back to what my Lord Mount said when we came in yesterday, which is that it may ultimately be much more important to focus on what the conditions are than whether you're under 5.1b or 5.1c. Anyway, that's Ostendorf.
But if you do arrest someone who's about to start a fight and you treat the obligation as being prescribed by law, as being the citizen's obligation not to start a fight, the arrest could be said to be in order to secure the fulfilment of the obligation not to start a fight.
Well, that's the gist of my answer to my Lord Reed.
Yes.
I mean, that it is so.
The point I'm putting is that 5.1b, on the authorities you've taken us to, is actually concerned with a different type of situation. It's not concerned with preventing breaches of a criminal law. It's concerned with securing the performance of positive obligations.
Well, my learned friend Miss Kaufmann's written case under this part goes through a lot of the breach of the peace case law. And she says, look, in every one of those cases, some warning was given not to do something. So in the famous Albert and Lavin case, it was don't push your way to the front of the queue and get on the bus. Now, I think it was my Lord Reed who asked Miss Kaufmann about that yesterday. Do you say, you asked, that simply asking somebody or telling somebody not to do something creates a specific legal obligation? And her answer was yes. So if that is correct, if saying to Mr. Lavin, please don't get onto the bus and push past everybody else because there's going to be a fight, is enough, why can't objectively the circumstances which lead any sensible person to know that if they push past somebody else on the fact everyone's going to get agitated and there's going to be a fight, be enough?
Yes.
Why do you have to be told, as you're about to hove a bottle towards the other crowd or you're about to provoke them into violence, that is something why do you have to be told by the police, don't do that?
Yes, I mean, it occurs to me as you're speaking that an answer to the point I put to you is that the approach in Steele of treating a binding over order as giving rise to a 5.1b obligation shows a wider approach than merely using detention to coerce people to perform positive obligations.
I'm not sure in Steele that the case was in the end decided on the 5.1b. It was a 5.1c justification. I'll look at that.
You say the obligation here was a negative obligation.
Was a
negative obligation.
Yes.
An obligation not to breach the peace.
Yes.
What do you say a matter of interest to Ms. Kaufmann's argument that if a police officer says, "Now don't move," then that creates...
Don't move.
Don't move.
Yeah.
That creates an obligation of the kind that 5.1b is addressing.
Well, it must depend on the facts, my lord. If it's don't move that way with your placard that is provocative, that may be enough.
But is that an obligation prescribed by law? I mean, the general law prohibits people from threatening breaches of the peace.
My lord,
Is a police constable's order don't move?
You do have
An
a
obligation.
general duty to obey the
Well,
police.
exactly. A, you have a general duty to obey the law, but B, more specifically, the constable has a positive obligation, albeit one of imperfect enforceability.
I'd be rather hesitant about laying down a general obligation
Well, I'm
on the part of the citizen to obey the police.
Absolutely not. Again, it must all depend on the fact. If you're walking around Parliament Square, minding your own business, and the police say, turn round and walk the other way, and you can't see, and you say to him, why? And he says, better not go too far, I've got the police behind me, and he says, well, because I feel like you walking the other way. You can plainly, in my respectful submission, without instructions, you can ignore him.
I'm just slightly cautious about the Supreme Court says that prescribed by law covers anything that the policeman
It's
ought
not
to
anything.
do.
It's if the police is giving
Well-
an instruction in order to avoid,
Yes.
pursuant to his duty to avoid breach of the peace, that's an instruction which should be obeyed. One would have thought. But can I ask you, what's the position if a lay person sees a breach of the peace about to occur? Is a lay person entitled to detain?
Yes.
Yes.
So,
Absolutely.
well, in that situation, if a lay person is required by Strasbourg to say, stop, there can be no duty to obey a lay person's order, but the lay person is nonetheless entitled to detain the potential breacher.
And going back to the lay person example, the idea that at the moment that the lay person, take the example of the domestic violence situation. There's a fight breaking out between a husband and a wife. The neighbour comes in and restrains the husband,
Yes.
being slightly sexist here, restrains the husband before he commits any violence against his wife, to await somebody calling the police to deal with the situation. Right. The idea that subjectively in the neighbour's mind there must be the intention of bringing the detained person before a competent legal authority is fanciful, and yet that is the effect of Miss Kaufmann's submission.
Yes.
Because the lay member of the public wouldn't have to worry about Article 5, would he? Because the lay member of the public simply wouldn't be impacted on by Article 5. He's not a public authority. He's not a public authority.
No, I suppose that's right. Can I just finally deal with one aspect of Milena Friend's written case?
Is he? I mean, that's interesting. He's acting in the interest of the public, but he's certainly not a public authority. Yes.
You can see all sorts of arguments as to whether he might in those circumstances.
That's right. Where is, anyway.
There could still be a complaint brought to Strasbourg on the footing that UK law permitted detention in those circumstances.
We needn't discuss the position of the off-duty policeman.
Right.
As the constable was in Albert and Lavin.
Yes,
That's right. Lord Reed's answer is the proper one. We do have to look at Article 5 in that context as well.
Yes, that's true. Just finally, at paragraphs 103, can we just turn it up? Milena Friend's written case, MS 103 to 105. You can see, starting at paragraph 133, at the bottom of MS 103, there are a series of cases, Kelly, Humphreys, Duncan, Piddington, etc., where Miss Kaufmann says, look, in every single one of those cases, there was a warning and it was breached. And that shows, she says inferentially, that a warning can always be possible, and it's not a problem for this court to impose an invariable rule that there has to be a warning before 5.1b can be invoked. And she then says, at paragraph 135 of her written case, the respondent doesn't suggest that any of the appellants were given any form of warning. I don't suggest that, she's right. But I do take issue with the next sentence. When properly analysed, there's nothing on the fact of the appellant's cases that would have rendered it impracticable to have informed them of the specific acts that they were to refrain from committing, as was done in all of the breach of the peace cases set out above. But on the factors found by the divisional court in paragraphs 171 to 172 that I took you to, that factual submission is not open to her. And indeed, it's telling that those authorities that I just showed you were precisely the authorities that her skeleton argument relied upon, or the applicant's skeleton argument relied upon in the divisional court. If you could just turn up...
Sorry, which authorities? That's the ones where?
The ones starting with O'Kelly and ending in Steele.
Referred to on which page? I didn't get.
104 to 105.
Starting
104 fact.
104 through to 106.
Yes.
A list of authorities
Yes.
which Ms. Kaufman relies upon to show that a warning could always be possible. And if you turn, please, to the appendix part 3 and to page MS 1028. Starting bottom of MS 1028, this was ground 3. The decision to arrest the claimant was a wholly disproportionate response to any perceived threat. And then at 108 recites all the alternatives, including warnings that Ms. Monaghan, who was then counsel, was advocating as potential alternatives to arrest. And then it says, paragraph 109, it is of note that in all the authorities considered by the House of Lords and Laporte, there were these warnings. And she sets all of those cases out. That was before the divisional court, under ground 3, the disproportionality ground. That was the ground that was dismissed by the divisional court in the passages I have shown you, 171 to 172, and permission to appeal was refused on that ground. So as I say, it is simply not open in this court for Ms. Kaufman to make the submission at paragraph 135 that there was nothing on the facts of the case that would have rendered it impracticable to have taken these measures. That is not what the divisional court has found, on the contrary. And then finally, just to answer the procedural question that I was asked before, the references given to me by Mr. Summers as to where the debate was had and resolved concerning whether there should be a witness action.
Yeah.
It's in the divisional court skeleton, MS 1053 to 1054. That's appendix part 3,
Yeah.
1053,
1054.
1054,
Right.
paragraphs 3 to 4, recorded by the divisional court judgment at paragraph 9 and dealt with by the Court of Appeal at paragraph 88.
Thank you.
Thank you. Those are our submissions.
Thank you. Mr. Summers? Thank you very much. Yes, Mr. Jaffe.
Thank you, my lord. My lords, briefly, 2 points. First of all, reflecting the Secretary of State's interest in the legal scheme, taking the Brogan point and therefore taking Miss Kaufman's case at its highest and on the assumption that the majority in Ostendorf were correct. And then secondly, I'd like to return to the point about 51B and about the conduct of an ordinary citizen and when an ordinary citizen can be expected to give a warning. 51C first. Mr. Grzyński showed your lordships the passages in the divisional court's judgment setting out the police's intelligence that they had before the royal wedding. Some of the leaflets that were circulating encourage people to bring maggots rather than paint. And so the police's understandable concern is that was the type of threat that they were facing. Maggots, for example, being thrown at those celebrating or participating in the royal wedding. Now, if we take that as a hypothetical example, and if we apply the common law to it, when a police officer notices someone in the crowd pulling out their bag of maggots or their tin of paint, opens it up and gets ready to throw it, the police officer will, of course, realise a breach of the peace is imminent, the situation is likely to quickly descend into violence, and they have a common law power of arrest. That's all straightforward and that's all common ground. If appropriate, if the police officer or the citizen can, they can take lesser action, short of arrest, if that will be sufficient. Under Article 5, the position as I understand it, in light of Ms. Kaufmann's submissions, is that if a group of police officers surround and contain our potential maggot thrower, there will be no breach of Article 5. That's the effect of Austin. Indeed, Article 5 will not even be engaged, even if the people need to be held in a cordon for a substantial period. Indeed, Ms. Kaufmann enthusiastically supports, as the human rights compliant solution to this type of public order situation, the use of containment, even if, as she candidly accepts, it involves cordoning a substantial number of people, many of whom may be entirely innocent, for a significant period of time, rather than arresting the single person who was the direct cause of the imminent risk of violence. The Secretary of State does have some doubts about that proposition. Holding innocent people inside a cordon may be necessary sometimes, but it also must be recognised that doing that offers fewer safeguards to the people whose freedom of movement is restricted. There is no right during containment or opportunity for prompt production before the court. There's none of the PACE Code of Practice safeguards, which are applied by analogy to breach of the peace of a custody officer reviewing detention. There is no opportunity to be fed, to be watered, to use the toilet. These are, of course, no small things on the facts of Austin, where the conditions did become unpleasant after several hours. There was no opportunity to see the duty solicitor, who can and will make representations as to whether or not detention should be continued, applying the test set out by my Lord Dyson in Williamson. So, what if containment is not possible? Because containment does require very extensive police resources, and with the best will in the world, and even with the best planning in the world, there may not be enough police officers nearby to effect an effective cordon. In those circumstances, the single police officer is really going to have no choice but to arrest a person who is about to commit or incite an imminent breach of the peace by throwing their maggots or throwing their paint, and take them down the police station. The reality of that situation is that at the moment of arrest, the arresting officer will have no concluded view, or even have time to think for more than a moment about whether to present the person to be bound over. Person gets to the police station, let's assume they're entirely unrepentant and says, yes, I will do this again next time there is a major event in London. At that point, the police take a decision to present the person to the magistrates. Again, it's still common ground that in this situation, the detention was lawful throughout under 5.1c. Those are essentially, I think, the facts of Nickel, where no decision appears to have been taken about binding over at the moment of arrest. And after the initial arrest, the custody officer recorded that detention was authorised to allow a period of calming and determined method of processing. That's MS 1747. And once that decision was taken...
So it's not critical, the initial moment of detention, you say. You can, if there is a requirement to have a purpose of taking before, it can be formed at a later date, a later time.
The reality of any urgent public order situation is the police may need to act immediately, using their common law powers to detain someone, to prevent an imminent breach of the peace. Their duty is then to consider whether to present the person to the magistrates for consideration of binding over. And the reality of a public order situation is that a single police officer, acting almost instinctively sometimes, is not going to have an opportunity even to form a view about future risk until the issue has been properly investigated.
So, I mean, how do you fit that into the plain language of C?
The plain language of C is fitted in because of the effect of Brogan. And take another example. Let's assume that the person gets down the police station, the police interview this person with their box of maggots, and it becomes clear that they are somewhat chastened by the experience of being arrested, they're perhaps rather young, and it becomes obvious that they recognise that they've made perhaps a rather silly mistake, and it's never going to occur again. In those circumstances, applying my Lord's judgment in Williamson, there is no longer any real prospect of the person being bound over, because the magistrates will not be persuaded to the criminal standard that there's a real prospect of repetition. And the duty of the police at that point is to release. But throughout that process, the police had a contingent intention, if the evidence justified it, on the facts as they emerged, to present the person before the magistrates if it was appropriate. That does not mean that they must do so in every case. There may be no sufficient evidence of a risk of repetition. There may have been a misunderstanding. It's perfectly possible that a police officer may apprehend an imminent violent breach of the peace, but on examination, the police officer has made a mistake. There may not be sufficient admissible evidence. It may not be in the public interest to present the person to the magistrates, but none of that negatives the conditional intention, which is sufficient in my submission, applying Brogan. And my understanding is, again, that in that scenario, it is conceded by the appellants that applying Brogan, 5.1c, is satisfied. So it's important to identify exactly where the appellants and the respondents in this case do part company from each other about the application of 5.1c. And I think it comes in a case where the officer arrests the would-be paint thrower or maggot thrower, but hopes and expects at the time of arrest that a person can be released within a couple of hours, and certainly in a period shorter than it will take to get someone before a magistrate. So, and that intention is ultimately realised. The crowds do disperse quietly, London becomes peaceful and quiet, and the streets become calm. And the person can then be released after the crowd leave, the police having decided there's no real risk of repetition. It is difficult in my submission to see why that is different from the scenarios which are recognised as within 5.1c after Brogan and Steele, because the police in those circumstances, and in my submission we are to assume that the police understand the law and will apply it, will present a person to be bound over, or for consideration of binding over, if the evidence justifies it. The police officer may have a preliminary view, or they may have no initial preliminary view at all, that it won't be necessary to hold someone for more than a short period, and they will probably not need to seek a binding over order from the magistrates. But if the public order situation deteriorates, and depending on how the person behaves when they're arrested, the police's initial view may well change, and it may become necessary. For example, if someone is highly resistant, if someone is abusive, or if someone expresses an intention, or the police infer from their behaviour that there's a future risk. If there is evidence to the requisite standard, the police will do their duty and they will present someone to be bound over.
You're accepting there has to be a contingent intention,
Yes.
whatever that means. And I think you're saying that the very context, the legal context in which all of this is going on, means that you impute an intention to do what the law requires.
Yes.
And the fact that the law may not, that on the facts that is not likely to be required, doesn't change that position, is that?
My lord, that's right. And that's because binding over under English and Welsh law is to be distinguished from the position in cases like Ostendorf, where there was no underlying criminal offence for convention purposes. In Ostendorf, the argument presented by the German government under 5.1c was rejected precisely because in Germany there was no criminal offence for convention purposes. So comparing what would happen if Mr. Ostendorf was a football fan in England, what would have happened to Mr. Ostendorf here is he would have been arrested. Given his history, it's very likely, if he was lucky, he would have been presented to the magistrates for consideration of binding over. If he was unlucky, he may well have been charged with an inchoate criminal offence, like conspiracy to commit violent disorder, contrary to the Public Order Act, because this country does recognise inchoate criminal offences in a way that German law does not. But in Germany, there was never any possibility of an offence for convention purposes at all. There was nothing, under any circumstances, which the police could ever have charged Mr. Ostendorf with. Here, in this country, there is the contingent possibility, if the police are satisfied that the standard for binding over is met, of presenting someone to the magistrates for consideration of a criminal offence in a criminal trial where they have to adduce evidence and prove their case to the criminal standard. And that's the difference in my submission.
You get assistance, don't you, perhaps, in this line from the fact that all that is necessary under Article 5.1c is reasonable suspicion of an offence. And to say, therefore, you have to believe on, as a matter of probability, that you're going to end up pursuing someone to trial is, on the face of it, contradictory.
Yes, it's not necessary to believe that you'll pursue someone to trial. You have to have reasonable grounds for suspicion that what we're calling an offence, even though...
I suspect I may end up requiring this person to be bound over.
Quite.
No.
I don't know. I hope not.
No.
But I will if I need to, once events are clearer and once I've properly investigated. My lords, that's 5.1c.
Yes, equally, if you detain someone for the purpose of questioning, as a suspect.
Yes. It's also important to recognise that when the police use a power of arrest, they inevitably have multiple purposes in mind. And one of the purposes that they have in mind is to restrain a person from freedom of movement, because they consider that is essential in the public interest. It is perfectly possible, indeed most criminal offences in this country are prosecuted without there being an arrest. An arrest is only used in circumstances where the police, in addition to investigating or on suspicion of offence, need to prevent someone from exercising full freedom of movement during that part of the investigation. And that's the context in which arrest takes place. My lords, briefly, under 5.1b, it's again common ground between the appellants and the respondents that, in principle, Lord Reed's paint thrower could be detained under 5.1b. The only dispute is to whether a warning or an instruction must be given by the police officer or by the citizen first. I think everyone also agrees that wherever possible, a warning is likely to be appropriate, and the absence of a warning will be a factor, often a very strong factor, in deciding whether or not deprivation of liberty is objectively necessary and justified. But when conduct is about to happen, shouting, "Please stop, don't throw that paint," may well be entirely counterproductive and lead to the opposite result from that which is intended. And it's also, I think, common ground between the parties that a warning is not always necessary in many public order situations. It is not necessary to give a warning before putting a cordon in place. That was decided in Austin in paragraph 22.
Sorry, not necessary to give a warning when what?
Before using containment, before putting a cordon in place. That's paragraph 22 of Austin. No warning was given in Austin because of the police's concern that they would simply not be able to hold the cordon if they told everyone to stay in the same place. People would run away and their objective would be frustrated. It is, of course, perfectly possible to use force in exceptional circumstances, including lethal force, without a warning where it's necessary to do so. It's also possible to detain under 5.1c without a warning where it's necessary. And for that reason, I suggest it does go too far to say that a warning must always be given in every case under 5.1b. And that links to the issue of the fact that these powers are not just exercised by trained police officers, but citizens who are not police officers regularly carry out their obligation to prevent a breach of the peace. And if B is indeed the correct framework for looking at this case, most people would understand that a warning is appropriate where it might make a difference and help prevent a problem. But most people would also find it difficult, in my submission, to understand a legal framework that requires a warning as a matter of law, even where the effect of giving the warning would lead to precisely the result which it's intended to be avoided. And that's the link between Article 5 and the reality of intelligent public order policing, which has been made repeatedly by the Strasbourg Court. As to how this applies to ordinary citizens, if Article 5 works in a way which is impracticable, that may not cause many problems for the Metropolitan Police, but it does, of course, cause problems for the Secretary of State, whose duty it is to ensure there is an adequate legal framework. And that's because Article 5 prevents arbitrary detention by anyone. And it's necessary for the United Kingdom to have a legal regime in place that only permits the deprivation of liberty for the reasons which are identified in Article 5. And so by having a legal regime in place under the common law which permits detention, if that legal regime that permits detention by ordinary citizens is incompatible with Article 5, then the Strasbourg Court will equally be able to find a breach against the UK in respect of action committed by an ordinary citizen. And that's why whatever solution the Court adopts to the issues which are raised in this case, the Secretary of State invites the Court to adopt a solution which works practically for breaches of the peace which are prevented by citizens, as well as action which is taken by a police officer. So, my Lord, it's almost like, I'm afraid, being the little boy in the Emperor's New Clothes. But it is quite important in this case to ask, where exactly is the arbitrary deprivation of liberty on the facts of these cases? It is quite difficult in circumstances where the divisional court has found there was an imminent risk of unlawful violence, no lesser means available, and the people were released as soon as possible to identify the infringement of fundamental rights that the common law regime has blithely missed or failed to provide a remedy for, which requires Article 5 to come in and cure and remedy. In the Secretary of State's submission, the true analysis is that Steele and Nicol and Brogan, which are of course all UK cases, have considered the issues of law which arise in this case and resolved them. That does not mean that some exercises of public law power, of breach of the peace powers, will not be found to be unlawful. Of the 5 applicants in Steele, 3 of them succeeded in Strasbourg on the facts, because it turned out that it was unnecessary for them to be detained because there was no imminent risk of violence. But the common law scheme under which they were detained and the test which applies under it are a set of provisions which do satisfy the requirements of 5.1c and 5.1b in the Secretary of State's submission. Unless I can assist my lords any further, those are my submissions.
Indeed. Yes, Ms. Calvin. Yeah.
Can I start by clarifying yet again what the issues are for our part that arise here? The claimant's, the appellant's position is that Article 5.1c does not permit purely preventative detention, by which we mean detention done solely for the purpose of preventing the commission of an offence, whether at the same time there is an intention to bring that person before a court in respect of that preventative purpose or not. In other words, it does not permit purely preventative detention. Now, some of the confusion, I think, has arisen because, unlike the situation in Ostendorf in Germany, where it was absolutely clear that the measure in question was a purely preventative measure, and therefore the issue arose in stark legal form, and there were no factual complexities, the position in this case is different because breach of the peace powers, an arrest for breach of the peace, is a power that is exercisable ordinarily in the context of criminal proceedings. Our case being that Article 5.1c operates purely in the context of criminal proceedings, that is, where the purpose of the arrest is ultimately to pursue criminal proceedings, whether conditional or not. So because this power can be exercised for an Article 5.1c compliant purpose, in fact it ordinarily is exercised for an Article 5.1c compliant purpose, a measure of confusion has entered in my submission to the position that the appellants are taking. Our position is that as a matter of fact, this power, which is capable of being exercised in a 5.1c compliant way, was not exercised in a 5.1c compliant way in the circumstances of this case, because the sole and exclusive purpose of detention was preventative. And by that, we mean that as and when the individuals were arrested, it was never intended that that arrest be in order to investigate whether or not a bind-over was appropriate. The measure was being used solely to get them away from the celebrations, to take them to a police station, and to hold them there until the moment when the celebrations were over. Now, we accept that things might have happened that meant that they couldn't, as a matter of fact, be released as and when it was expected that they would be. We accept that it might have happened that they couldn't, in fact, have been released before it became appropriate to take them to a magistrate's court. But our submission is that does not convert the purpose of their detention from a purely preventative purpose to one which was also for the dual purpose of seeking a bind-over. The law might have required the production before the magistrate's court, but that does not make it the purpose. So in our submission, when one reads Article 5.1c, the reference to purpose in the long-standing jurisprudence of the court is a reference to an objective which is criminal. That is, to look into whether or not a criminal offence has been committed, which should then be the subject of a trial before a court. That is what the purpose of bringing the person before the court refers to in Article 5.1c, when either read alone or beyond any doubt, when read together with 5.1a, which is concerned with post-trial, when read together with 5.2, which identifies that arrest is arrest in the context of or in relation to a suspected crime, and most importantly 5.3, which requires, put aside the prompt production before a court, it requires and confers an entitlement to a trial within a reasonable time. And that is trial necessarily of the criminal offence in relation to which the individual has been arrested. And then we come back to the grounds of detention, which are permissible within Article 5.1c, being bases upon which somebody can be detained in the course of the pre-trial process. That is, while they are being held for the purpose of a criminal trial. And Brogan, of course, means that individual doesn't have to be produced before the court before a trial if the evidence at the end of the day doesn't stack up. But the purpose for which they are held in the first place is to investigate a criminal matter for the purpose ultimately of bringing them before trial if trial is appropriate. And if one starts from that premise, and we again look through the authorities to which we've been taken, Neither steel, nor nickel, nor lawless are at all inconsistent in any way with that construction, and we'll come on to that in a moment. But before we do, can I just deal with the maggot example that we just had from Mr. Jaffe? So we have a situation where an individual is in the moment about to throw some maggots. What can the police do in that situation? Well, the answer is very simple. They can arrest him. Because at that point in time, it will be impossible to say at the outset that the arrest is only going to be preventative. That person is to be taken out of the situation, and given the conduct of that individual at that moment in time, of course it will be appropriate to investigate whether or not a bind over is appropriate for that individual. So it will be impossible to discern from those circumstances that it was not a 5.1c detention. But we're not dealing with that if we are right about the factual context in this case. We are dealing with a situation where the detention was only preventative. And I started by saying yesterday, there is no need to rewrite Article 5 in the way that is being argued for by the respondent and as was done by the Court of Appeal, precisely because breach of the peace powers can be exercised consistently with Article 5. Either, take the maggot example, you arrest that individual within the confines of Article 5.1, or in a situation where it isn't absolutely clear, or where it is absolutely clear that you will never be seeking a bind over, therefore it is not appropriate to invoke Article 5.1c, you can fall back on 5.1b. And that is what the court did decide in Ostendorf, and my Lord Toulson raised the question, or was it my Lord Reid? I apologise, raised the question of whether or not the court had considered, the European Court had yet considered circumstances such as these, an evanescent situation. And the answer is yes, they have considered such a situation. They considered such a situation in Ostendorf, and what they decided is, we don't need to rewrite 5.1c to cater for this situation. We don't need to permit purely preventative detention under Article 5.1c because 5.1b is there to do the job. You can make the obligation, which is established by the police in aid of the prevention of a breach of the peace or crime, concrete and specific, by specifying to the individual what that obligation is. And again, remember, we are talking about circumstances here where 5.1c cannot be invoked. So where it's clear there will be no need for a bind over, in that situation, you can make the obligation concrete and specific as is required by 5.1b by giving a command as to what the individual must be prevented from doing. And if they manifest an intention not to comply, you can then arrest them, detain them, deprive them of their liberty. So both 5.1c and 5.1b, when coupled together, can cater for the situations in which the police, in a public order setting, will need to prevent a breach of the peace. And it mustn't be forgotten that 5.1, that an arrest or a detention of an individual can also sit alongside the numerous other powers that the police have to prevent a breach of the peace, which does include kettling, where one is dealing with a large-scale public order situation, because, of course, kettling is appropriate where you have a large number of people who are threatening a breach of the peace, and you can't arrest all of them at the same time or detain all of them individually in order to take them to a police station. I was not for a moment suggesting that kettling is a preferred option. What I discussed yesterday was yet another alternative, and that is the alternative of finding a space away from the threat of the breach of the peace where individuals can exercise their right of peaceful protest. So now going to answer some of the specific points made by Mr. Grudzinski yesterday. The reference to fair balance, which was taken from the case of Austin, I refer again back to the paragraph 172 of the A case, where the Grand Chamber specifically rejected the appropriateness of invoking fair balance when it comes to construing Article 5.1, because they said in terms it runs contrary to the way that 5.1 itself is drafted, which sets out an exhaustive list, it runs contrary to the constant jurisprudence of the court that it must be strictly construed. So resort to fair balance in that instance was had to invoke a device, which this court is clear about. It was a device. What, on many people's view, would have been a deprivation of liberty was found not to be a deprivation of liberty as the only way to ensure a fair balance. But that cannot work in relation to rewriting the constant jurisprudence of Article 5.1, A, and the UK and the Grand Chamber decision there. Second point made by Mr. Grzyński was that there are a whole series of protections and safeguards in the common law. We don't need to be worried if we rewrite Article 5 because we know that there will not be arbitrary detention in this country. But rewriting Article 5.1c, as I said yesterday, in the way that the Court of Appeal has done, has opened the way for judicial internment. And judicial internment runs contrary to the long established jurisprudence of the European Court. Even if not arbitrary, we do not countenance in democratic states judicial internment or executive internment. And there is nothing in Article 5.1c which would limit the duration of that internment. As long as it remains necessary and proportionate, that internment could go on. 5.1b, on the other hand, is available to deal with short-term administrative detention made necessary by an evanescent, passing moment of the threat of criminality or violence. So again, there is simply no need to make that fundamental rewriting. Lawless, paragraph 14, the critical paragraph in paragraph 14, is looking at Article 5.3. It is looking at the requirement in Article 5.3 that the person who has been detained for the purpose of bringing him before the court, and I accept they didn't need to address what that purpose was, that is in connection with criminal proceedings. Once they're brought before the court, they have in the terms of Article 5.3 a right to a trial within a reasonable time. If that doesn't happen on that occasion, then all that the court in Lawless was saying was then, if you're not going to have that trial on the merits, the trial which was the very purpose for which they're brought before the court, then you've got to decide upon the lawfulness of their ongoing detention. Yes, that's what 5.3 requires, but it is also 5.3 connected to 5.4, which gives rise to the right to have the legality of the detention determined. So there's nothing inconsistent in Lawless with the later reading of the court in Schuller that the purpose you bring that person to court for, ultimately, the ultimate purpose is for a trial in relation to a criminal offence. Lawless and Schuller stand together. So you arrest them in relation to criminal proceedings, you decide you've got enough evidence to charge, you bring them promptly before the court, and the court at that stage then says, well, are we ready for a trial of the criminal charge? No, we're not. Okay. This individual's detained, we better decide upon the lawfulness of that continuing detention because they're entitled to a trial within a reasonable time, they're entitled to release without pending that trial unless the conditions justifying their detention obtain. There is absolutely nothing inconsistent between Lawless and Schuller. Equally, there is nothing inconsistent between Steele and, before I come on to those, the case of Mackay, Volume 6, tab 57. That was a classic example of Schuller in operation. You have an individual who has been arrested in respect of a criminal offence. That person is charged. They make their first appearance before the court, and the court under 5.3 is not ready to proceed with the trial, and therefore they determine the legality of their detention. But the critical point is, that's not an end of the matter. They retain their right to have a trial within a reasonable time. And the very purpose for which they were brought before the court was to have that trial, to be charged and to have a trial. Now, it may be that later on, after their first appearance, just as it might have been before they ever made their first appearance, that the evidence crumbled and it was not appropriate to have that trial. But they had a right, when they were arrested in connection with criminal proceedings, should a charge be brought, to have a trial and to have it within a reasonable time. So Mackay is entirely supportive of the Chiller construction. Steel in the UK and nickel, again, entirely supportive, because the starting point in those cases was that the individuals at the time of arrest, or the police officers at the time of arrest, had it in contemplation that a bind-over might be appropriate. So always in both those cases, the purpose of their arrest and detention was to bring them before a court for a criminal trial. The fact that the grounds upon which they were then detained, pursuant to that purpose, or in support of that purpose, were at one stage preventative, and thereafter, on the basis that once the preventative need had gone, on grounds of reasonable suspicion, is neither here nor there. The ancillary or the anterior purpose with which 51C is concerned, C. Chiller, of bringing them before a criminal court was always there. And all we are dealing with, where the court refers to these two grounds of detention, is entirely in keeping with the constant jurisprudence that once that purpose is fulfilled, you can be detained on any one of those three grounds, either reasonable suspicion, or if that's not enough, preventative purpose in respect of a specific offence, or to stop you fleeing. Entirely consistent. And what is highly significant is not for a moment did either the court in Steel or the court in Nickel think that they were departing from the constant jurisprudence, address the constant jurisprudence, and state that they were taking a different course. And it's hardly surprising they didn't do that, because nothing they were doing was inconsistent with that constant jurisprudence, it being the case that the arrests were in connection with criminal proceedings. So it is completely impermissible in our submission to look at those authorities as somehow demonstrating that the European Court has taken a different course from that taken in Chiller, followed by Jethius, followed, as we shall again see, by the Grand Chamber in the decisions of Al-Jeddah and Hassan. Brief reference to Williamson, that was in volume 1, 3, tab 86, page 1424, paragraph 26, I think, I'm sorry. And that is where the court in Williamson did make reference to the Nickel decision, the Steel decision. And what it held was that the court, paragraph 26, although the court did not have to deal with the complaint under Article 5.3 in Steel, it's clear, in my view, that the common law requirement that a person detained for breach of the peace must either be released unconditionally or taken to the magistrate's court as soon as reasonably practicable reflects the provisions of Article 5.3 quite closely. Well, it does, because the whole reason you're bringing them before the magistrate's court is to secure a bind-over.
I mean, you don't have any problem with that paragraph 26, do you?
No,
because there was an original expectation that they might be brought before the magistrate's court, and that then they were taken by possibly being released.
And the legal requirement to take somebody for a magistrate's court is to secure a bind-over. Yeah. That is a criminal process. There is nothing in that decision which undermines in any way the constant line of Strasbourg jurisprudence. Chiller, 2.6, volume 2, tab 6. We were taken to a passage which Mr. Brzezinski relied upon at around paragraphs 38 to 40 as showing that here the Strasbourg court was actually not...
Sorry, 38 to 40 of where have we gone?
Oh, sorry, this is the Chiller decision, volume 2, tab 6. Can we start at paragraph 38? This is a paragraph of general application to Article 5, 1C. The court points out that subparagraph C permits deprivation of liberty only in connection with criminal proceedings. Not 5.1c insofar as it refers to the detention for reasonable suspicion of having committed a criminal offence is only in connection with criminal proceedings. No, detention under 5.1c. And then if we turn to paragraph 39, halfway down the page, The second paragraph, in the court's view, the preventative procedure provided for in the 1956 law was designed for purposes different from those of criminal proceedings. The compulsory residence order authorised by Section 3 may, unlike a conviction and prison sentence, be based on suspicion rather than proof, and the deprivation of liberty under Section 6, which sometimes precedes it, as in the incident case, accordingly cannot be equated with pre-trial detention as governed by Article 5.1c of the Convention. They could not have been clearer what criminal proceedings are. Criminal proceedings are the trial for an offence, conviction and punishment thereafter. There was no mistake in Chulla, and in Gethius, the court made equally no mistake in following it. It was plain what criminal proceedings meant, and that is precisely how the term was understood in Gethius, precisely how the term has been understood in Schwaber, precisely how the term has been understood in Ostendorf, and so too in Al-Jeddah in the United Kingdom and Hassan in the United Kingdom. Now, yes, it's true that Al-Jeddah and Hassan were concerned with internment. But the point was, the court said internment does not come under 5.1c because 5.1c is concerned with detention in the course of criminal proceedings. Its observations were not irrelevant to the decision in issue. They were critical to the decision in issue. The detentions in those cases could not fall within 5.1c because 5.1c catered solely for pre-trial criminal detention. So it's wrong to say the Grand Chamber hasn't spoken. The Grand Chamber has spoken very clearly, repeatedly, in a number of cases, all entirely consistently. And then we come back to the question of, does the Court of Appeal's analysis actually make any sense of this provision? And the answer, again, we submit is it doesn't. We can't just ignore the third limb, which Mr. Grzinski again tried to do. We've got a little commentary on it in Van Dyck. They recognise in Van Dyck it's deeply problematic. So what they try to do with the third limb is to create a wholly impossible construction of Article 5.1c in the sense that it simply is nowhere apparent in the words that this construction could be right. And what they seek to do is to say that the third limb, in some way, detaches itself from the first two limbs and becomes a separate ground upon which an individual can be detained where the predominant purpose of detention is one or other of the first two limbs. Now, in my submission, that is an utterly absurd construction. The three limbs stand or fall together. Either you can detain for the purpose of bringing the individual before the court to determine the legality of the detention by reference to each of those limbs, and then we're presented with the problem of judicial internment, we're presented with the problem of indefinitely detaining somebody to prevent them from fleeing after committing an offence you are never going to try them in relation to, or you recognise that the reference to purpose in 5.1c is to an anterior, quite separate purpose, and those three bases of detention are simply grounds upon which you can detain somebody in pursuit of that purpose. And I come back then to the question of whether or not the second limb is robbed of any value. I think Mr. Grzinski raised this point in relation to the German situation. He says, well, if in Germany...
Well, does your interpretation make sense or treat the three limbs as on a similar basis? Reasonable suspicion of having committed an offence is, on your case, surely something that's got to be present in every case, because otherwise yes. You wouldn't. So,
but we come back
to an alternative to the other two cases. It's not an alternative basis. That's the whole point of your case. It is not an alternative basis to the other two cases for bringing someone before a competent legal authority. It's an essential basis.
It's an essential basis to start the criminal process. That's quite separate from the basis upon which you then detain somebody in connection with the criminal process. 5.1c is identifying when, in the context of a criminal process, you can detain individuals. So yes, you can't start the criminal process unless you have reasonable grounds to suspect, but when can you then detain somebody? In some instances, the presence of reasonable grounds will be enough. In other instances, that won't justify detention. But it may be you can then justify detention on the basis you've got to prevent them from committing a specific and concrete offence, or it may be you can justify the detention on the basis that you want to prevent them from fleeing. Each of those three grounds is there to identify permissible bases of detention, not necessarily sufficient bases, but permissible bases of detention. And that's when one then has to ask oneself, is detention on these in principle permissible bases justifiable as necessary and proportionate? So again, the question of the purpose of the proceedings is separate from the question of the basis upon which you detain
someone. When is
someone.
reasonable suspicion of committing an offence, having committed an offence, by itself sufficient to justify detention?
Well, for a long
without
time.
considering any other factors?
For a long time, it was thought, for example, in relation to murder, it was for a long time thought if you were suspected of murder, you didn't really need much else.
Yeah, but you've said preventive detention is not permitted by 5.1c. I think your argument has to go, but suspicion or anticipation that somebody may be about to commit an offence entitles you to arrest as a step towards concluding whether there is any reasonable ground for suspecting something for which you can prosecute. That has to be the purpose all along.
So
I think that's how your argument goes.
in a situation where, as here in this country, you can arrest somebody, it is an offence in and of itself to do preparatory acts,
Yeah.
then you would be justified in arresting somebody for the purposes of instituting criminal proceedings, investigating.
You wouldn't need limb 2 then.
I'm sorry?
You wouldn't need limb 2 then.
No.
Because
Question number one.
that will bring you within limb 1.
Question number one. Do I have grounds to investigate the commission of an offence? That's the first question. And if you have grounds to start investigating the commission of a criminal offence, you then ask yourself, in this jurisdiction, do I have reasonable grounds to suspect this particular individual? Let's say you've got over that hurdle. The next question becomes, do I detain this individual in the course of my investigations? That is when the three grounds kick in.
But sorry, if you've got reasonable suspicion that the person has committed an offence, then you can arrest and you don't get to the second limb.
But you can't necessarily arrest on that ground. That's the whole point. It's not necessarily sufficient. What Article 5.1c is identifying is it's identifying the permissible bases.
Yes, well, I follow that. But you've got a permissible basis if you have reasonable suspicion of him having committed an offence. So you don't need necessarily to any alternative ground. The question is, when can you arrest?
Can we look at
On
the case?
sorry, can I answer my question?
I'm sorry.
When can, I know we're running out of time, but when can you arrest in order to prevent an offence, but where you don't have reasonable suspicion that he's committed an offence? And I thought the logic of your argument was you can arrest to prevent an offence where you don't have reasonable suspicion that he has committed an offence in order to, as it were, buy you time to work out whether you've got reasonable suspicion, provided that your purpose all along is to take him to court.
No.
That's not it.
No. My case is
You have to have reasonable suspicion.
you have to have reasonable suspicion
In all
in this
cases.
country. In this country, the criminal process is not commenced until you have reasonable
Or
suspicion.
or is not a true alternative.
It is a true alternative because reasonable grounds to suspect may not justify you in detaining.
It isn't a true alternative because it ought to then read or in cases where reasonable suspicion of having committed an offence is not by itself sufficient, then, provided there is such a reasonable suspicion, when it is also reasonably considered necessary to prevent us committing an offence. You'd have to, the or suggests, as Lord Toulson's putting, that they are disjunctive.
The or
But your strong point, of course, is that fleeing can't by itself. Nobody sensibly thinks that fleeing is a ground by itself of arrest, so you must be implying something there anyway.
But equally, the ors can simply be identifying three potential bases. Could I ask the court to look at the case of...
I think in view of the time, we've probably run out of time for exhaustively or trying to understand the drafting, and I suspect the draftsman took less time on it than we have.
That's very true. Could I just, for your lordship's pen, ask your lordships to look at the case of Ladent, which we didn't look at yesterday, which is in volume 5, tab 54, and the relevant paragraphs are 55 and 56, and they are relating to Article 5.1c detention. They're looking at circumstances where reasonable grounds to suspect do not suffice, but there may be other grounds.
Which tab was this? Tab? Volume 5, which one?
Tab 54.
54, yes.
Volume 5, 54 of Volume 5.
Fine.
Relevant paragraphs are paragraphs 54 and 55.
Yes, I've got those. Yes, well, we've got the proportionality point, yes.
And 55 shows not just the proportionality point, but it addresses the specific grounds of detention in 5.1c, shows how they don't always operate to justify detention. So even if one were to accept that Cayenne had somehow extended the court's remit in terms of its freedom to depart from Strasbourg, we would submit there is absolutely no basis to justify departure in this case, because the jurisprudence is constant, long-standing, long-established, hasn't been questioned, save in relation to some dissenting opinions which misunderstand the existence of any conflict between lawless and chiller and so forth. The Grand Chamber has expressly identified the limits of Article 5.1c, insofar as the Strasbourg court hasn't addressed English law, it's addressed a much more difficult situation, namely German law, where 5.1c is not capable of being engaged at all because it's not an offence. And, of course, 5.1b provides the basis upon which you can detain in any event. So, can I just do one final 1 second check that I
want to detain us a little longer?
Yes, I want to deprive your lordships of your liberty for approximately 30 seconds.
1 minute.
1 minute of deprivation of liberty. Can I just ask the court, when going back to McVeigh, to read paragraphs 169 and 172, where we have the French text laid out, and that's where the
So where's the French text laid out?
I'm so sorry. So it's McVeigh. And
oh, yes.
McVeigh, I've now lost the reference, but it is 9 of volume 2, and the key paragraph is 169, where we see the French text, which does make specific reference to there being an already existing obligation.
Have we got the whole of the French text of Article 5 there?
Well, we've got what's in McVeigh, I'm afraid. But that gives the clear...
So what does the French text say?
So it makes it clear that the obligation is one which is an antecedent obligation which the individual has so far not complied with. So that is a very critical part of the language of Article 5. But in addition to that, I simply reiterate the point made yesterday that
It's the point, yes, qu'il a négligé jusqu'ici à remplir.
Yeah,
which they have neglected until now to fulfil.
No, well,
Yes. That's not the text of the article, is it? It's,
yes.
It's the court's judgment in Engel.
Yes. Yes.
I think it's simply the French version of the court's judgment in Engel.
Oh,
Yeah,
I'm
so it's
sorry, that's my misunderstanding. I've always read that
it's
as
the Engel judgment. Well, we can read it. We will look at the French text of the convention as well.
And I would simply then, I've completely forgotten what I'd simply do. My last point I've forgotten. Yes, I, so far as the layperson is concerned, of course, it is necessary for the state to clarify the law. I accept that on behalf of the Secretary of State. But a layperson is either going to be in a situation where they can make an arrest because they are confronted by an assault. That's what they're dealing with if the breach of the peace is so very imminent that they could not issue some warning. Or they could confine a person or restrain a person having issued that warning. And finally, very finally, the need for concreteness and specificity comes not only from the language of Article 5.1b and the constant jurisprudence that there must have been an obligation, an antecedent obligation, but it comes from the point also in the long-established Strasbourg jurisprudence that so far as breach of the peace or the prevention of crime is concerned, these are too general, these obligations, and therefore they must be made specific and concrete by an individual being told in terms what they must do in order not to breach those broader obligations. And can I just leave two bits of facts for your lordships, two pieces of factual evidence. I'll give the references. I'm not asking your lordships to read them now. They are at page volume 2, and this is MSP 524 and 527, and it's Inspector Morgan's tactical log, which shows the preparations for enabling the protesters to gather in Soho Square to protest away from the celebrants, and his entries at 6:35 and 8:21 in his occurrence log for the day, page 536 to 7 and 537. Sorry, 536 to 537.
Thank you. The court will take time to consider its judgment and will notify the parties and hand it down in the usual course. Thank you very much.